Excellent. Welcome to Immigration Legal Tech Conversations presented by Visa Law AI. Excellent. Welcome to Immigration Legal Tech Conversations presented by Visa Law AI. False start. That's on me. Where am I picking that up from? That's on me. Where am I picking that up?
Didn't start until after we hit live.
Yeah, let's see. Hopefully that. Let's see. I've got my. Oh my goodness. One moment. Let me close some tabs here. All right, we should be good. All right, sorry about that. False start. Welcome to Immigration Legal Tech Conversations, where we're going to be talking today about a really important case, Greg, and I'm really glad to have you on. We had on February 10th a very major ruling come down in how that we should be thinking about using AI in legal proceedings. And so I'm excited to talk to you today about it. And you are joining us today from Budapest. What are you doing over there?
In Budapest right now, I'm just touring a little bit, but we're going over to Krakow midweek, where I am speaking to the ALA Global Migration Section meeting at the in Krakow, and this is a conference of immigration lawyers from a lot of different countries, and I'm going to be talking about AI with them, and taking notes from how immigration lawyers are using AI in other countries, so that I could take it back and share. So it should be a good panel.
Yeah, it sounds like a great panel and a really great time to do it now, as well as we get this new ruling, which has come out of a case here in the Southern District of New York.
Yeah.
And so as we get into this, Greg, I want to give a little bit of background because it's certainly an interesting story on its own, outside of the entire implications that it has for the larger legal and artificial intelligence usage aspect. So for anyone who's not familiar, on February 10th, a ruling came down. This came from a criminal proceeding where in December 2024, before the arrest of Bradley Heppner, former CEO and board chairman of GWG Holdings, he found himself at the center of this case, this scheme to misappropriate more than $150 million, which is certainly a serious accusation for a shell company that he controlled. So in December 2024, Heppner and his defense team entered into a statute of limitations tolling agreement with the U.S. Attorney's Office and in the Southern District of New York. And this agreement was intended to provide Heppner a window to present information to the government and engage in discussions that might forestall a grand jury indictment.
Right. It's a white-collar criminal case. It's not an immigration case, but we'll talk about why it matters still for immigration.
That's right. And so it was during this time period in 2024 that Heppner turned to Anthropic's Claude to help synthesize a defense strategy and draft a response to the evidence that was coming up against him. So the government's discovery of this activity stemmed from standard discovery. In the pretrial phase, the defense produced a privileged log to the government. And all of this was listed as documents of artificial intelligence generated analysis, conveying facts to counsel for the purpose of obtaining legal advice. These included things like documents, PDFs uploaded to Claude that were, for loan agreements. They're like cards between people. There were receipts that he had, and all of these things uploaded to Claude for legal analysis and to help him basically provide an executive summary for his defense team about what was there. So the government moved for a ruling that these documents were not privileged, arguing that the moment Heppner input confidential case facts and defense theories into Claude, he disclosed those secrets to a third party. So this disclosure, the government contended, was a voluntary act that forfeited the protections of attorney-client privilege. And that's sort of the background on this case and what makes it really, really interesting. And so, Greg, do you have any initial thoughts as to really high level what this means?
Yeah, I mean, there's a couple of things that are here. So, I do a lot of talks about legal ethics, and for immigration lawyers and for lawyers of different categories, and I talk a lot about confidentiality and why certain tools, you should basically consider them not to work from a perspective of complying with Rule 1.6 on confidentiality. There's another aspect, though, to this that's sort of a cousin of this, which is on privilege. And this involves the client and what the client can hold back from the government based on the fact that it involves communications with their lawyers. So I think in this case, the law firm, I think it was Quinn Emanuel, they had they had shared information with the client, and the client then took that information and put it into Claude to be able to get additional documents to help. I mean, I don't know specifically what was in each of the documents, but basically it came with input from the law firm. This person was, it's really irrelevant that they were going the DIY route on some aspects of this, but it's okay. I mean, a lot of sophisticated clients do that, and that's fine. But the part that they didn't count on was the fact that these communications are now suddenly potentially all available to the government that would have normally been protected, and they wouldn't have had to share with the government. So there's two different arguments I think that they made. One is that this privilege argument, that they didn't have to turn things over because it involved confidential communications between a lawyer and a client. And that's where the confidentiality part comes in about the tools that you're using. And then also there are protections for attorney work product that don't have to be turned over as well. So if the attorney had a memo that was kind of describing the issues to the client, that would be attorney work product. That would normally not be something that could be gotten in what's called discovery, which is when the government can ask you to produce documents. So those two things come up, and they don't work anymore in this case, because if you pass information on to another party and it's not done in and that party doesn't have the same privilege, then all bets are off as far as your ability to protect those documents. So this is a clear warning for lawyers broadly, immigration lawyers too, about and there's a couple of things that lawyers need to advise their clients about. And we all worry about this as far as, we can have use cases, not use cases, but training sessions and internal, law firm use policies. We can have, tools that we know are guaranteeing confidentiality. You can do all the right things as a lawyer, but if your client's the weak link, you may lose all these things that you were doing just to protect your client when they may lose it themselves based on things they do. And I should say this is not a new problem as far as electronics communications. It's been a problem for years and years. Even started with email, this idea that because email was hackable, this was a real thing back in the 90s, because email was potentially hackable. Was it unethical to use email to communicate with clients, and could clients themselves, by participating, waive their privilege on there? Now, of course, that became a non-issue over the years as there became an acceptance that it was a reasonable way to use it. Kind of the same way, if you have a phone call with a client, you can work under the presumption that it's not tapped. The call is not being tapped, even though in theory it maybe it could be. I'm not an expert on tapping phones, by the way, or on hacking emails, but that was the idea. In this case, though, it has to do with the version of the product makes a big difference that was being used. So in this case, we're talking about the consumer, the consumer access Claude. And it wouldn't matter if you were talking about OpenAI's ChatGPT or Gemini or whatever. There are these consumer level products, and then there are the enterprise ones that and that the distinction is important because the consumer ones, they make it very clear in the in the terms of service that you're not you don't have an expectation of confidentiality. um, they may be training on your documents that you're putting in. They also, in the terms of service, reserve the right to have human review. We've talked about that before, and that's if they see something inappropriate. And in a criminal case, they might see something. If they're seeing somebody that's talking a lot about wire fraud and things like that, and the AI just kind of flags it as like, oh, they're talking about crimes. It's not a zero chance that somebody in another country, usually not the U.S., is going to be looking at the transcript to see if there were terms of service violations. And that's and there are good reasons for that. But that's the fact that these tools work that way means that there's not an expectation of confidentiality. And if it's not confidential, it's not. It's as if you published it for the world to see, and there's no privilege that you can claim. So that's different than the enterprise models. The enterprise models, by contract, and this is also not just enterprise for them, but tools that maybe use Claude or use ChatGPT for their backbone, but are using an API, or you're getting an enterprise agreement and the enterprise deal. And the difference is not actually the technology. You may be accessing precisely the same models. The difference is the agreement with Anthropic and the agreement with OpenAI. And in both of these cases, whether it's an enterprise or an API version, these generally speaking, and it may vary from company to company, and that's why you should always look at the terms of service. But if it was one of those versions of the product, then you would have an expectation of maintaining privilege, because those companies don't actually, by contract, they don't have access to training on the documents or going in and looking at your chats. And that's and it might have been for Mr. Heppner, who the case is United States versus Heppner, that if he had used, a product that maybe, that he had at the company level, well, that probably would create different problems. But let's just say he had his own enterprise level account. The guy is a Wall Street guy, and we're talking about this kind of money, then presumably he could pay for a $200 per use version of it. But that apparently was not the case here. So that's so that's important. But it also there are lessons for the lawyers in this as well. And it's not just don't count. Your clients may be doing things that will run counter in the case. And I am sure that Quinn Emanuel, if they had any clue, well, first of all, it assumes that they even understood what these about how the tools work. But that's the first thing, is lawyers should have just a general understanding. Even if you're not using AI yourself, you should have a general understanding about how these tools work and what the implications are for confidentiality and privilege, because the people that you are working with, maybe your co-counsel at another law firm, maybe your clients, whoever is involved in your case, what they're doing may have implications for what you're doing. So that's number one, is make sure how the tools work, and then give appropriate warnings in your engagement letter to your clients. Have an actual conversation, maybe make them initial around a document showing that they understand that taking confidential communications and entering into one of these models may waive all of that, waive privilege, and may create other problems. But have that conversation with your clients, and then internally. So, by the way, I'm not changing the subject. It is about this. So, I was on a panel last week in Atlanta. I think you know that, or it was the week before in Atlanta. And I was it was an AI panel, and I was speaking with an ethics professor, Jennifer Romig at Emory Law School. It was great. She actually, this case had come out, I guess, the day before, maybe, or a couple hours before our panel, because I had seen a headline about it. I knew really very few of the details, but she's an ethics professor, so this was like she was diving right into that. She educated me about that. But my other panelist on it was a former immigration judge, who was Elizabeth Young, who was talking about this the shadow IT problems at EOIR, which is the Executive Office of Immigration Review, which is the immigration courts. And the shadow IT problem is what I'm getting into here. So what is shadow IT? Shadow IT is what your team is really using in your office and not telling you about, because they're not allowed to use certain tools. And I became acquainted with this. I mean, I knew that lots of people were using ChatGPT in their offices, and they kind of didn't really have permission, or they were using it at home. But I remember a conversation I was at Legal Tech in January, maybe of 2023. So it was really 2020. It was a couple of years ago. Anyway, there was a lawyer from a big law firm who was a big shot at the firm, and he was coming over to see what we were working on, because we had a booth there. And we were just talking about AI, and I was asking him about whether their firm had started exploring any of these tools yet. And he said, "Oh no, we have a policy that nobody's allowed to use any of this stuff, so it's not being used at our firm." And I said, "Oh, it's being used at your firm." You just don't know it's being used at your firm on there. And that's worse than trying to control it and educate people and make sure it's not being misused. You have no control now because you basically banned the product on there. It's like, so I've been familiar for a while about it, but I don't think I had heard the term shadow IT until this panel. And shadow IT is like a big problem for the same reason it was a problem for Mr. Heppner, which is that lawyers in your firm that are using tools, like if you ban ChatGPT in your firm, for example, your lawyers that are using it are just using, or your paralegals or whoever, are just using the free or the $20 a month ChatGPT or Claude. They're not using enterprise level. They're not using, something that's a legal facing product that might save the day on confidentiality on there. Instead, they're using these tools where everything that they're putting in there is potentially, waiving any confidentiality. So that's the problem that I think for a lot of firms that say we're not doing it. We're not letting people use it, is that it is like saying to your kid when they go off to college, well, you're 18 years old, you're not 21 years old, so I know you're not going to be using alcohol there, so I don't need to have any conversations with you about responsible drinking on there, because it's illegal and you won't be using it. It's kind of the same way of saying these tools are illegal in your office. They're going to be used, and they're not going to be used responsibly, and they're going to get your clients into trouble, and they're going to draw bad headlines. Like we know the 900, I think as of my panel from the other day in Atlanta, there were 916 hallucination cases already for that. And that's a decent chunk of those are lawyers who were using the public tools because their firms didn't have didn't invest in legal tools, and these lawyers were in a number of these cases using these products without permission in their firm. So anyway, it all comes back to the Heppner case because in the Heppner case, you have a client that presumably didn't communicate to the lawyers they were using those tools. But it also is, people within a law firm that are using these tools and they're not telling anybody that they're being used, and that's a problem. It was a problem as well in this case for claiming attorney work product because the information, Anthropic's, first of all, it is interesting. The judge kind of looked at the judge looked at what the terms of service stated for Claude, and it says in there that Claude itself follows the principle of choosing the quote response that least gives the impression of giving legal advice. Right. And they're explicitly disclaiming providing legal services. And you can't claim you used a tool for legal advice itself when the tool says it doesn't provide it. So a lot of times when people are talking to these bots, they feel like they're talking to a lawyer. They feel like you're talking to an expert on it. And, I get why that's a problem. And it's a problem for people that are, that are DIYing it in their legal matters because they feel like they are getting a substitute for a lawyer with ChatGPT, and they're not. So, but going back here, this this policy, the Anthropic has that, overall statement, and then their policy itself states that their outputs may be disclosed to government regulatory authorities and used to train their model. Right. And the judge has found that there was no reasonable expectation of confidentiality when the terms of service say that. Yes. Of course, nobody reads the terms of service, but it is important when you're discussing things, involving a criminal prosecution of yourself.
And it's probably important. It's probably important to know for anybody who's using, whether you're a lawyer or not at this point, that essentially what this finds is that when you publish prompts and receive things from Claude or ChatGPT, if you don't have those enterprise protections, you're essentially publishing whatever you are inputting because it is effectively training the models, and it could be used as source information for whatever that may be. As you said, for reviewing safety and training purposes, retaining data on servers.
And by the way, the law firm had to cover, do a CYA here and cover itself, but they had conceded that the documents that Mr. Heppner created, were created of his own volition, and that the law firm did not direct him to run those searches, which means that he was, he was trying to claim the work product protections, and it didn't work here because the law firm is not going to, lie to protect the client and that information from the client. So they had to actually, answer that question directly, and that so he didn't fare any better on that one. So that's a there are things that law firms should be doing, and one of them I'm going to get to. We have a question on enterprise level, and it's sort of a good entree to that. But you need to be auditing what your organization's AI usage policies say. So there's two parts of that. One is you need to get rid of the shadow IT problem and make sure that if either you really decide to trust implicitly everybody in your organization, or you provide some AI tools and put a lot of guardrails and parameters regarding how they're being used. And those tools should be tools that don't have the privilege or confidentiality problem. So I'm happy to say our Visual AI, we built it for lawyers. So of course that's the very first conversation that most lawyers typically have with us. But that's that's the case with any of the legal tools. I'm not aware of any that are of the major ones, that are at least the ones I know about, that I would be concerned about that. But you can use, directly tools like ChatGPT and Claude if you're using the right versions of those tools. So we have this question about, what do I mean by enterprise level? Enterprise level basically means that these are tools that are created for organizations, and they're not created for individuals. You have individual access to use it, but the accounts are sold to an organization. And the difference isn't necessarily, it could be, but it could be exactly the same version of the product that you're using at the consumer level. The difference is the agreement that your organization has with the company, the AI company, and the agreement will cover things like not training on your models, and not turning information over to government agencies, and not having humans in the loop and reviewing them. And there's all kinds of differences in the agreements that are in the enterprise agreements and the API agreements that are at the consumer level. So that is the difference. Now, it is possible to buy, and it's usually a lot more expensive to be getting that. So that's why I was saying it's going to be more like $200 a month than
Greg,
if you're getting it individually.
And in the Heppner case, he was using the free version, but it wouldn't have mattered if he was using the $20 version or the max version of Claude, unless he was in an individualized enterprise agreement, which you would know about. You would know if you were using an enterprise agreement if you were, because you would have gotten, spoken to OpenAI, you would have spoken to Anthropic salespeople and entered into a contractual agreement thereof. So even if
they do have these pro agreements that are very expensive as well, that might work. But the lesson is you have to basically review. Don't rely on a list of the company, the products and the versions that say that they are, that you have read somewhere that meet the level. You should read the terms of service yourself if you're using any of these, to see what they say on there. I even have done things like take Claude's terms of service and ask ChatGPT to find all the things in there that should concern you as far as a lawyer goes, and so that you can figure out what you can use it for and what you cannot use it for. And that's also not to say you can't use the $20 a month ChatGPT or even the free one. There, you can use them all you want. Like, I used it today to help me figure out a couple of things I was going to do today in Budapest, and it's really good for those kinds of things. But I wasn't particularly worried about training the model on my question about how to, what restaurant is within 500 yards of where I'm staying on here. So there, you can use those tools. You just can't use them for legal work, or for anything else, for that matter, that you are that you wouldn't want anybody to know about it. So that's that. Now, I did promise that we were going to talk a little bit about how these tools might be of concern. How the Heppner case might be a concern to immigration lawyers. And I did want to say that there are lots of instances where you might be tempted to put in information about your case, and maybe have information coming from your law firm. So it might be, your lawyer is saying, we need to beef up this section of your asylum claim because, it's probably borderline, and so and then the client takes that and starts to go out and ask a bunch of questions about country conditions, that maybe are designed to puff up a claim that might not be great, or for that matter, to help falsify something, which would be, really serious of a problem. But it is that's the clients need to be warned basically about the same thing, which is don't take anything from your lawyer and put it into one of these models, or you might as well just hand it right over to ICE or USCIS, the documents from the lawyer, because that's essentially what you're doing on there when you do that. So, if a client even if the client later shares AI outputs with you to seek legal advice, the court, has held that that's not going to retroactively cloak materials with privilege. So, if they give you something if you give your client something, then they turn it into something that like you get instructions on writing a declaration for yourself from the lawyer, and they might, on there, all the communications about how they told you to do it, the lawyer, it doesn't matter that it produced this new document, this declaration on there that you think is privileged. Anyway, so just note that there's lots of examples in immigration law where that would be an issue. So, don't basically, if you're directing a client to use a specific secure AI tool to draft a statement or organize a timeline, you're going to have a colorable argument maybe for work product protection, but you're going to have a much stronger argument if it's, if they've used the right kinds of tools for it. If they haven't, that's going to be a problem. So lawyers should be really careful about telling clients to use AI to help them prepare things that are related to their cases. Even if you think it would help them do a good job, if you're concerned about potentially, something going south later on that case, and those communications being shared, or the clients not having any protection in what they're producing there. So that is sorry. Go ahead.
I did want to ask, because one of the things that was mentioned in some of the articles that we read was, because Heppner in this case basically did this on his own. He wasn't directed by his lawyers to, do this at all. One of the things that was brought up in the articles was the Covell doctrine, which was interesting to me. So, obviously this is the privilege that extends to non-lawyers that are assisting the counsel.
Mm-hmm.
Do you think that AI will become, like an accountant or some other counsel, third party that this will begin to extend to, if lawyers are able to be like, hey, you can put this information, if you want a summary of some of this stuff, if you're, go ahead and use AI. Is there a path forward for applying AI to the Covell doctrine?
I mean, I think you could potentially. Well, first of all, I think it's going to be a while before we can say AI has any of the same protections like you would have of a person as far as asserting those rights. But to the extent you have tools that are not, that meet the test, then I think I could see a day when, and maybe not, and maybe some firms are even doing it now, where law firms are making an AI assistant available to clients with it, basically with tools that they know would withstand the scrutiny regarding privilege and confidentiality. And I think this is getting at your question, but it's if a law firm said, you know what, we know our clients need to use AI for certain things that they're working on. We're giving them big assignments as far as things that they need to produce for us to get ready for whatever process we're doing for them. So we're going to make sure that they're using a tool that will not, that maybe, and it's not just potentially on privilege. I mean, maybe they have tools that are designed to reduce hallucinations. Maybe they have tools that are sort of drafting tools that they've already configured to do certain kinds of things that are client facing. So I can see that being, those arguments going further in that way, when the law firm has a lot more control over what's being, how the tool is being used, and vetting the tools that are being used.
Yeah, and I suppose for me, like the question kind of comes up where it's like, this happened, this ruling came down a few days ago, but
Right.
this action that this client took was in 2024. I'm kind of wondering, for all of the people who, in between now and then, like there may be a lot of really sensitive information that's already sort of exposed. And is there a way to protect, or is there any actions that lawyers should be taking today that could, just to cover ground for clients that they may be taking on, between when
Well,
AI has come out and.
first of all, it's sort of like, probably only a low percentage of these cases are actually going to get to the point where, I mean, this in a criminal case, there's already a criminal matter going on. In a immigration proceeding, it's probably not going to get to that point in most of the time where there would be any attempts by the government to retrieve this kind of information, at least on the way things operate right now. But as far as, I think that's pretty much, well, I mean, first of all, this is one judge. That's also important to remember. This is not the Supreme Court. This is one judge in one district. Now, it is influential because he's the first and it's gotten a lot of publicity. But there could very well be other courts that take a more relaxed view about it. So we'll have to see that. I do know, I mean, this panel I'm speaking on in Krakow, I'm going to be talking about this case, and I'm going to be on with a UK immigration lawyer who has said that there's already a case in the United Kingdom that has been dealing with this subject on there. But in the US, we just have, this is, as far as I know, the first case to deal with this in the United States. We did have the OpenAI copyright case where, 20 million people, account holders, had information that was accessed by the government that was turned over by, I guess, as part of the discovery in that case on there. But that's and that there are arguments regarding confidentiality there. So this is a cousin of that. It's not exactly the same arguments, but I would expect we're going to see more of this, and we're going to probably see, more, if we start to see this rise up to the circuit courts, and there seem to be, a split in decisions where it's being treated differently by different circuits. I mean, I could see an issue like this eventually going up to the Supreme Court. But, right now it's just one district court. So if it comes up again, I would imagine that somebody could make the same arguments that Mr. Heppner did and potentially come out with different results in a different court that just looked at this subject differently. And it also may be that the courts start looking at things differently as time goes on, and certain principles get agreed on as far as what's reasonable and what's not. And we also might start to see some of the user agreements from some of these companies change to look more like enterprise agreements. If it looks like, they're not, that somehow, I mean, certain products are probably going to come along and say, you know what, I can make a lot more money by talking about how we're not training on your data, and we're not, and confidential is confidential on there, and there's no third party that's looking at it, and we're not doing, and we have zero retention. That's another thing we didn't talk about yet, but that's another thing that, if you're choosing legal tech and the company says there's zero retention, no training, and no human in the loop, that's what those are the things you're looking for. There may be consumer level products that eventually are out there, like the DuckDuckGo of AI. DuckDuckGo, a lot of people might know, is the web browser that is competing they're the little guy, but they're competing with Google essentially by talking about these things that they're not spying on you essentially, and sharing your information and mining it to be able to sell ads to you. So, I would think there's room in the market for an AI product that can promise those things. And that might change the debate a lot if it becomes kind of a moot point where, with one of these, the major one says, we're going to do these things and make this a non-issue. Then you've got, it may be that we'll be looking at this nostalgically and saying, oh, remember in the early days of AI when we were really worried about this and companies were doing these awful things. Well, they may not really be awful. I mean, don't you want a person in Kenya to know if you're looking up instructions on how to build bombs and things like that? I mean, probably on there. So there's some
I'd like to know that. Yeah.
there are some legit reasons why you want a human in the loop at these companies. And I think we can likely assume that a lot, these enterprise customers, people aren't using it for those kinds of purposes. But that is but although I'm not sure, even in DuckDuckGo, if you're running those kinds of searches, I think it's pretty much all things go over there. But that's what it would probably take to, if all the companies basically do this, then I don't think there will be much of a discussion anymore on the privilege issue because it just won't be it won't be relevant. But for now it is, and right. I think people need to be careful about that.
So for any attorneys who are looking at this and they're looking for things to do, I think really the first thing to do is audit whatever your company policy is, and see, what agreement you're in with, whoever. If you've got an enterprise account, you should maybe check into that. You should maybe be trying to research, whether there might be, products that are focused specifically for your industry, whether that's immigration, whether that's, whatever it may be. You should probably be looking into those or finding an enterprise agreement with, one of the larger companies. And the questions you should be asking those companies are if they have a no retention policy, and working out an agreement, an enterprise agreement with them, a formal contract there, not just getting, the paid you're not just paying $20 a month. Like you're going to need probably something a little bit beefier than that. Checking out if they've got things like SOC 2 Type 2 certifications, and then just understanding their terms of service. So I think those are all sort of immediate takeaways. I
did have one last thing. It's I was talking a little bit about a law firm that maybe makes an AI available to their clients. But I also wanted to remind people that, first of all, you should be having conversations with your clients that about how you're using AI. And I have told people, it's like, don't be afraid. Most of the time clients want to know you're using AI because they want to know that you're using every tool at your disposal to improve the way you're representing them. But I will tell you that something that you can do is you can have counsel-led use of AI with their clients. So I've had instances where I'm doing a screen share with a client with visa law on there, and they know that I use it. I talk about it on live streams like this every week, and post about how I'm using it. But I have done, instances where, for example, I have a prompt that I like to use with and I used it this recently with a client where you can upload a resume. You can upload a prompt to help you come up with basically analyze the resume and give you talking points and things to discuss for NIWs or EB1 cases, and then have sort of and we have a discussion about what we're seeing on there. But I'm sort of like giving them. I'm not it's spotting things for me that are helpful and for them as well. And I'll ask them further questions about this or that. But AI can be kind of helpful in improving those conversations. But I can also see instances where if you're asking the client to do, drafting something like a personal statement or a declaration, and you're doing a screen share and you're working with the client in terms of, suggesting to it how to, how you want to ask the bot to give you guidance, and how to, and maybe, doing instant translation so that the person can review it in their own language and see that they're happy with it. I mean, there's all kinds of ways that you can do something counsel-led, where you're collaborating with your clients and being able to get to the place that you want, using tools that are not going to be problematic from the privilege or the confidentiality perspective. So that may, the upshot of the Heppner case is we may be seeing lawyers that are looking at using these tools with their clients, rather than just their clients doing it on their own outside the knowledge of the law firms, or just be doing it completely separately from the firms, as opposed to using it on platforms that they agree are okay.
That's right. And I think the thing is there's going to be so much that comes from this, and it's certainly not, it's the beginning of the conversation, not the end, for sure. And so that was the Heppner case. And obviously that was important to talk about, but Greg, I also want to give you an opportunity to talk about the 10th edition of the Physician's Immigration Handbook. In celebration of that, you created 14 new prompts that could be used.
I did. Yeah. So So the first of all, this Physician Immigration Handbook on there, I'm the co-author with Elisa Taub on that, and Elisa does really for I think the first edition I had written on my own on that, and then Elisa joined me for the next 9. But Elisa she's doing the lion's share of the work on it. But we just had the 10th edition. The book comes out every year. So one of the cool things was, for that is I said, I'd like to. I've been thinking more. You can upload a PDF in Visa Law and potentially other products as well, where you can you can design a prompt around the book, and so I have come up with a bunch of prompts that can be run in our product, but potentially other places. Again, keeping in mind that you're going to be potentially putting in confidential information, so you need to do something with the right tool. But within the, if you go to prompt.law, the prompts are there. They will be soon in Visa Law itself, although you can go to prompt.law and copy any of them over. And some of the examples, in this space, there's something in Physician Locum Tenens Immigration Compliance Analyzer. What is that? Most of you won't know what a locum tenens is, but these are basically temps that are physicians that go for 6 months in basically to a location that can't find a physician. And I actually have clients who go all over the world doing locum tenens. But anyway, there are all kinds of immigration issues that are more complicated for that type of doctor than there are for others. I had tools for help physician recruiters and third-party placement companies analyze immigration risks. I have tools I have a prompt to help people figure out that are coming over for residency or fellowship training, whether they should look at what's going to work best for them, the J1 or the H-1B visa, because a lot of times they have a choice, sometimes they don't. For doctors that are choosing green card strategies, how to look at how to compare perm versus physician NIW green card strategies. There are tools on how to pick the right J1 programs, all kinds. So that is, they're all there. If you go to prompt.law and you go into browse prompts and you just type the word physician, you'll see all of them pop up and you can read them for yourself.
So that's super exciting for folks. And I know that that'll be, it's also an excellent segue from our last conversation. Make sure that you are using the right tool. Make sure that if you are, and it's, that's what we've been talking about. I feel like, every episode it comes up at least once because it's really the most important thing. Make sure you're using the right tool. at the end of the day, make sure that you are using these tools properly. And if you haven't yet explored using an AI in your practice, find the right one for you. There's lots of new ones that are coming out. There's ones that have existed in the market as well. Obviously, we think you should use visa law if you're handling immigration issues, but there's a lot of different options for you out there at this point in time. And there's probably going to be more in the future. But yeah, this was an incredibly interesting conversation today, Greg. And if anybody wants the notes from today's topics, and we'll send the prompts out as well, a link to prompt.law, you can scan the QR code and we'll send that to you here this week. But this was an incredibly interesting case. Is there anything else about it that you want to highlight or just think about before we leave off, Greg?
No, although I feel like it seems like every week there's some new angle that we have to think about AI and how we're practicing. And I guess most of us just haven't been focused that much on anybody. All our focus has been internal and monitoring what's happening at our own firms, but internal includes our clients, even if we're not, and that basically opens up this whole new can of worms. So I'm hoping that firms start, this case will at least get firms having a conversation about that aspect of their operations and how to be proactive in working with clients to make sure that this doesn't become something that is is a problem. And it may be as well that if you don't talk about these things with your clients, some judge out there is going to say that it's reasonable if the client sues you for any host of things, that you might be found liable because you should have had this conversation with the clients. I don't know that we're at that point, but that's the other thing you need to think about. It's not just the ethics rules. It's also your malpractice insurance that might be an issue here as well. So just keep that in mind.
Excellent point as well. Absolutely. Well, Greg, I appreciate you joining us. And if anybody is going to the AILA Chicago event on March 6th, they can see you there talking on another panel too.
And that's my next one after this.
That's very exciting. So you can find us there, and you can find us on visalaw.ai as well if you're curious to learn more about, if you want to see what privacy and security measures might be, things you need to look for. We've got an entire page on that. Good stuff to check out and know and be aware of. So with that, Greg, I think that's pretty much everything today. Really excited.
I was just going to say, everybody in the northeastern part of the U.S., I know you're going through a lot right now. Hopefully you'll be unburied soon, and this won't be as much of a headache as the last round of weather was a few weeks ago for a lot of us. So glad I'm not in your areas.
I'm so glad we're not getting any snow in this. I am very glad about that.
All right.
All right. Thank you, Greg.